Well, ladies and gentlemen, Saturday, this thing about to begin. Ladies and gentlemen, and discerning viewers of the court gallery, welcome, welcome, welcome. It is a Saturday, and that means it's time for a weekend court review. I am your lone wolf, Usul. I am here to present to you some very interesting court cases, at least I think they're interesting. And we're all going to get to watch them together. The first thing we got on deck today is Judge Hudson. He's got a two-part Sov Cit case. Starts in April and it moves on into May, where we are right now, just yesterday. Then we're moving on to Judge Lewis, who is a little bit of a new one, but we've covered him a little bit before. He's in Lakewood, Washington. And then we're wrapping everything up with the eponymous Judge Ricky. And it all starts right now.
Yes, next I have Jose Elizondo.
Good morning, Your Honor. My Christian name is Jose and my family name is Elizondo. I am the bailior today and respectfully ask some issues to raise.
Wait, Mr. Elizondo, wait. Jose Elizondo, I show that you have one case pending and that is expired registration. Do you understand that's the charge that is pending against you?
Yes, I understand, but respectfully.
Okay, sir. Okay, hang on. There's several steps we need to take over. Were you able to hear my explanation about defendant's rights and options that I went over at the start of court?
Yes.
Do you have any questions about those rights or options?
Yes.
Go ahead. What's your question?
Okay, respectfully, I haven't received my documentation that I requested in a timely manner to proceed today.
No. What is your question? No, Mr. Elizondo, no. What is your question about the rights and options that I went over at the start of court?
I have no questions regarding that.
Okay, then to this charge of expired registration, actually, I'm going to stop and say, you mailed in payment.
I did.
You mailed in $3 and you have a balance due of $129. So with that payment of $3, we've already entered a plea of no contest for you because Texas law allows that to be entered for you. So we're set here to determine, are you able to make the balance of your payment by Monday, or do you need some time to pay that out?
Your Honor, respectfully, as a bailior and grantor, I've granted this court equitable title for settlement of any.
No, sir, this is a criminal court. No, sir, Mr. Elizondo, this is not a civil court. There are no parties like that in this proceeding. You're a defendant. You're not a grantor. I'm the judge. And so that does not apply to this court. You may have read that might be something in a civil court. That does not apply here. So my question to you, sir, is since you've already mailed in payment and indicated a plea of no contest by mailing in a payment under Texas law, can you get the balance paid by Monday, or do you need some time to pay that out, or do you have a financial situation that you need a financial packet?
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have registration.
This is not that, sir. This is not, Mr. Elizondo, stop. Mr. Elizondo, stop. This is not the time to make a statement. You see, we have like 12 other people who are set here. You're set on a criminal charge. This is not time for you just to go and make a statement about a civil matter that it is not set in this court.
So are you saying that I don't have civilian due process of law?
No, but this is not a civil matter. You're raising terms in regards to this as if this were like a civil lawsuit. This is a criminal charge where you've already. It's not
criminal, Your Honor.
Yes, it is, sir. This is a Class C criminal charge in Texas, displaying an expired registration. That is a Class C criminal charge, and you mailed in partial payment. So I'm trying to determine, are you able to make the rest of your payment by Monday, or do you need some time to pay it out?
I have the right to equitable title for this settlement or any charges on the doctrine of trust merge.
This is not a matter of a title to a vehicle or anything like that, sir. You seem to be confusing some civil law.
Well, I have some confusion because on Supreme Court case law Murdoch versus Pennsylvania, they clearly state that you don't need registration or insurance for private personal travel, and I don't consent to any corporate Ponzi scheme.
Okay, well, this is nothing to do with a corporation. This is a Texas charge, and you've already mailed in a payment for this. So you've indicated a plea of no contest. Are you saying that you're not pleading that? Then why did you give them $3?
As a bailior and grantor, I gave
Mr. Elizondo, stop. Mr. Elizondo, stop. Mr. Elizondo,
of trust merge.
Mr. Elizondo, stop. Why did you mail in $3?
Because as a bailior and grantor, I have granted to this court equitable title for settlement of any.
No, sir. We do not settle. And, sir, Mr. Elizondo, there's no party in a criminal charge that's called a bailior, and you cannot claim a position that is not one in this court.
Your Honor,
There's
are
no
you giving
status
me-
of bailer.
Are you giving me finance?
No, sir, listen, I
Oh.
need you to listen to me. I need you to listen to me. There's no status of bailer or grantor in this criminal court. You may have read some cases in regards to some other matter. You are a
can you give
defendant.
me-
No, Mr. Elizondo, you need to be quiet and listen. You're a defendant. You mailed in $3, which is partial payment of a total of $132. All right. Now, by law, when you mail in a payment, a plea of no contest is entered. All right. So my question to you was, when you mailed in the $3, was that your intent to make a partial payment, requesting a payment plan, or were you attempting to post a bond?
My intent was, like I said, I am the bailor and grantee. I have granted this court equitable title for settlement of any charges under doctrine of trust merge. That's my answer to your question.
Okay, that is not an answer that applies in criminal court. So based upon your payment of $3, the court has already entered a plea of no contest, and I'm going to order that you get the balance paid
Your Honor,
within 30
respectfully.
days.
Okay, Your Honor, respectfully, with those documents that you have, I didn't receive any documentation requested in a timely manner to proceed today. Outlining my full loan tone under Chapter 66 of Texas Civil Practice Code, which
Okay,
is
stop,
provable.
Mr. Elizondo,
and
Mr. Elizondo, stop. The Civil Practice Code does not apply to this courtroom. This is the Code of Criminal Procedure applies to the criminal courtroom. So the Civil Code does not apply.
But I still have a civilian due process, Your Honor.
Well,
And I have
yes,
not
but
entered a plea.
you did by mailing it in. By mailing that in, that's entering a plea of no contest. You mailed in a payment of $3.
Your Honor.
You can
Like
get
I
the
said,
balance paid.
The reason why I did that as a bailor and grantor, like I stated multiple times, I've granted this court equitable title for settlement.
Okay,
under
Mr.
any
Elizondo.
doctrine of trust merge.
Mr. Elizondo, were you wanting to plead not guilty and request a trial?
No. Respectfully, Your Honor. Constitutionally, too. For the record, I am a Texas common law free man. I do not participate in any Ponzi schemes that require me to have registration and insurance. I do not consent quasi jurisdiction. Respectfully, Your Honor, I plead for a civilian due process of law.
Okay, well, you're
Under
receiving.
Section 1, Article 10.
Okay, Mr. Elizondo, you're receiving the exact same due process that every other person who's appeared in this court has. And you have mailed in a payment of $3, and that payment is received as a plea of no contest.
Who is my accuser, Your Honor? Respectfully.
The state of Texas. The citation that you received, that is the accusation. And
okay, well, I would like to go to trial for this.
So you're indicating that you wish to change your plea from no contest to not guilty?
Yes.
All right. And you wish to waive your right to jury trial, or do you wish to request a jury trial?
No.
So no jury trial. You wish to waive your right to a jury trial?
1 second, please. Never mind. Give me a jury trial, please.
So you wish to request a jury trial?
Yes.
Okay. And you will be representing yourself, or will you be retaining counsel?
Myself.
Okay. Do you understand that if you request a jury trial, if you're found guilty, in addition to the regular state court cost, there is an additional jury trial court cost that's assessed if you're convicted. Your case is going to be reset for a pretrial hearing that is going to be for our May contest docket, which is at 6 p.m. on May 7th. Now, you will receive a written pretrial order. Make sure you read it and follow it. If you wish to have any motions heard, you need to have them filed pursuant to the order, so they will be heard that night. If you have any requests for jury charges, you need to have those prepared and filed that night. You will have an opportunity to speak with the prosecutor, and you will have your hearing on any motions that night. At that time, we will schedule your jury trial for a later date, so have your calendar ready. Be prepared to know your availability for the next 2 to 3 months after the May 7th docket. Watch your email. You'll receive the pretrial order. You should get it by Monday at the latest. If you haven't received it by then, call my court staff. They will resend it to you. Make sure you send everything in writing in response to that. If you have any requests for discovery, If you have any other motions you want the court to consider, they must be filed pursuant to the order. Do you have any questions about that, sir?
No, Your Honor. Thank you so much.
All right, we'll see you back here May 7th at 6 p.m.
Yes, ma'am. Thank you.
Here you go. So, Mr. Bishop, we have one defendant, Jose Elizondo, who's set for pretrial hearing. And I need to go ahead and call that, and then I'm going to get the interpreter for Ms. Mohammadi. Okay, so Mr. Elizondo, you have case G 4791701, charges expired registration. You were in court in April 1st, I believe it was, and indicated that you wish to plead not guilty and represent yourself, but you were not waiving a jury trial. So we set this for pretrial hearing. Court issued a pretrial order that was sent to both parties. I do not show that either side filed any motions or requests for subpoenas or request for jury instruction. Mr. Bishop, did the state file any?
No, Your Honor.
Okay. Mr. Elizondo, did you file any?
Yes, I actually certified mailed it to y'all. I have the receipt right here.
When was it mailed?
It said you should have received it on the 1st of this month. It was mailed on 04/29/2025.
We don't have it.
Well, you should have received it on the 1st. I certified mailed it.
Do you have the green copy back?
I have it right here.
No, the signed that it was delivered.
I mean, I have a tracking number here, but I haven't tracked it. It just says y'all should have received it on the 1st.
Well, we have not received it. We have not received anything. And everything was supposed to be filed with the court no later than 7 days prior to the pretrial hearing. So if you were sending it in on the 29th, you were not getting it here within the 7 days. What's the tracking number?
It says it shows delivered on my side, but let me see. Let me pull it up. The tracking number is 9589.
Oh, go slowly. Go slowly. I'm going to take this down and we're going to check 95 what?
958907105270018077.
Let me read that back to you. Check and make sure I have this correct. 95890710527030018077.
And then at the end, it has a 12.
12.
Yeah. That was correct, though.
All right.
Read it back.
Court is going to go into recess and look up the tracking number. Everyone stay logged in, but we're going to be in recess. All right, Mr. Elizondo, Mr. Bishop. So, Mr. Elizondo, I just had my court staff run that number through USPS tracking, and it does not show that it's been delivered. It still shows that it is in transit. Are you saying that you are looking at something that says it's delivered? Not something that's estimated. Are you looking at something, sir? You said this shows that it was delivered. What were you looking at?
Well, it says estimated delivery date, but I mean, I can look up the tracking number on my side too.
Well, no, I have. I mean, you can look it up, but the court has. So that the court is taking note that it does not show that it has been delivered. And so, what motions were you filing, or what were you filing?
I was just trying to post bond, but I mean, I'm still going to proceed to declare not guilty, regardless if you got.
You don't need to. You said post bond. You don't have to post a bond. So was that just a bond you were sending in?
Yeah.
Okay. No, you cannot post a bond yourself. Okay, unless are you a licensed bondsman?
No.
Okay, so you have a promise to appear, and that's all you need to have at this time. You don't have to post any sort of a bond. So you weren't filing any motions. You were not filing a motion for discovery or any requested jury instructions or anything like that.
I was, but I can't remember what I filed, but I have the documents somewhere else. I don't have them on me right now.
Where would they be? Why do you not have them on you? Because if you thought that this is your pretrial hearing, this is where they were going to be heard.
Okay. I still wish to proceed now guilty. I don't need them to
No, sir,
proceed
stop,
anyways.
stop. We're not going to the plea at this time. I'm trying to confirm. I asked you, I stated that we hadn't received any motions, and then you said that you mailed them. We've not received that. Then you said to me it was a bond. So I'm trying to determine. You were just trying to file a bond, is that correct?
Yeah,
Okay. You did not have any written, you did not have any written motions or requests for anything, is that correct?
that's correct.
Okay, so then, since you don't have to post a bond because you have a promise to appear, we can go ahead and set this for jury trial. So jury trials will be during the day. We'll start at 9 a.m. Parties are to be here at 8:30. The venire panel will be here at 9, and we'll have the trial. So the first date that we have is August 28th, which is a Thursday at 9 a.m. All right, so Mr. Elizondo, we're going to set this for trial Thursday, August 28th. At 9, you need to be here at 8:30. This will be in person in the courtroom.
That's
If
fine.
you are planning to call any witnesses, you need to have them here, present, to be sworn in and able to testify. Understand?
Got it.
Okay. Do you have any questions about this?
No. Well, are you going to send me this information via email?
We're going to send you a reset notice. Yes. Yes.
Make sure that email is correct, because today I received the email saying this court hearing was going to be at 6 a.m. and I was present.
Sir,
and it was 6
I
p.m.
apologize if there was a typo. I do know that you also received numerous communications from the court that said 6 p.m. And when I set you for this hearing, I told you it was at 6 p.m. So you were advised that by the judge, and we have copies of emails and documents that were sent.
And make sure that
Sir, Mr. Elizondo, do not speak to the court that way. You may make a request, but do not speak to a judge and tell them to make sure to do something. Do you understand me, sir?
Yes.
All right. You are set for jury trial on August 28th at 8:30 in the morning. The venire panel will be here at 9. You'll have an opportunity to ask questions of the venire panel, make any strikes that you wish to have. We will have the trial on August 28th. Make sure you have any witnesses here, any evidence that you're wishing to present, have it here and marked and ready to be admitted. All right. We will send reset notice, setting notice to the same email address that we've sent the other notices to. Mr. Bishop, is there anything that the state needs to put on the record at this time?
Nothing from the state, Your Honor.
Okay. Mr. Elizondo, if you don't have any further questions, then you are going to be released. We'll see you back here in person on August 28th at 8:30 a.m. All right, you're released at this time.
Now we're moving on to Washington State, Lakewood Municipal Court. Ladies and gentlemen, starting now.
Madam Interpreter, I believe that's all the cases we have on for interpretation.
Yeah, I believe that I have one more case at 11.
Yeah, for the Nisqually calendar, that's correct.
Jacinto Esteban Filiberto.
This is Mr. Tudor, Christopher Tudor.
Thank you very much. Sir, you are Christopher Allen Tudor. Your date of birth is September 26th, 1982. Thank you, sir. This is case 11U000282. Mr. Tudor is before the court for a review hearing. It appears previously Mr. Tudor had been charged with 1 count of domestic violence court order violation. The court imposed or granted a stipulated order of continuance agreement on March 20th, 2020. It appears that, I believe that stipulated order of continuance agreement, if I'm not mistaken, was later revoked. Let me take a look here. Jabs is moving slowly. Yeah, it appears that SOC agreement was revoked by Judge Adams on March 20th, 2020. Court took 5 years of jurisdiction. A number of conditions were imposed. It appears that the only issue that the court could identify with non-compliance with the terms and conditions of the judgment and sentence are subsequent law-abiding behavior violations, convictions that had been entered since Mr. Tudor was last before the court in order to have law-abiding behavior as a condition of suspended sentence. Mr. Vinson, what is the city's position?
Your Honor, the city is having difficulty pulling up his jabs. I just got it. Your Honor, the city knows that this is a 2011 protection order violation. The city would request that the court impose the time that he served at this time and close. Give him credit for time served.
Thank you. Ms. Horwath.
We're in agreement with the city's recommendation, and we would like to be appointed on this case. We've never represented Mr. Tudor.
And he does qualify?
Yes.
Thank you. Court will make that appointment. Ms. Horwath, how long has Mr. Tudor been in custody on this case? You know?
I believe he was just booked because he was just added to the calendar, but let me double check when this.
Thank you.
Day before yesterday.
Day before yesterday.
Yeah.
Yeah, it's saying less than 24 hours. He said the day before yesterday.
It's been more than 24 hours.
So we'd ask for 1 day credit and close.
No objection.
Court is going to follow that agreed recommendation. The court is going to find violations of the terms of the suspended sentence based on subsequent convictions since Mr. Tudor was last before the court. Those convictions were entered in Spokane Municipal Court for criminal trespass in the first degree, 2 different cases. There's also a pending charge of theft in the 3rd degree out of Chelan County District Court. Court will find the violation, impose 1 day in jail, give Mr. Tudor credit for 1 day that he has already served. And I'm going to indicate that the case is to close upon certification that he has served that 1 day and that Mr. Tudor is to be released at this time. Court has signed that order. Thank you, Mr. Tudor. You should be released later on today if there's nothing else holding you, and the court is closing your case in this matter.
Thank you, sir.
I'm sorry, who is this?
It's the first individual on the calendar.
Thank you. And sir, you are, is it Fayula Fiu?
Yes, sir.
And your date of birth is December 24th, 1986? Good morning, sir. This matter is before the court for a review in case number 18L000740. Previously, Mr. Few entered into a stipulated order of continuance agreement with the prosecution regarding a charge of 1 count of domestic violence court order violation. Judge Adams revoked that stipulated order of continuance agreement and imposed a 5-year suspended sentence on March 27th, 2019. Shortly thereafter, Mr. Few failed to appear for a review hearing It appears that Judge Adams indicated that there was non-compliance with conditions of suspended sentence. Specifically, there was no proof of domestic violence, victims impact panel attendance ordered by the court. Also, domestic violence evaluation in compliance with recommended treatment.
My client's indicated to me that he did complete the VIP at stop. I don't think it's ever been filed and I don't have proof of that, but he did want the court to know where he completed it at. I believe there is an agreed recommendation of the parties for credit for time served and to close the file.
Mr. Vincent?
That is correct, Your Honor. Given the date of this this violation, history, the city would be requesting that it be imposed and then impose and close matter.
Court will accept the stipulation to violations of the terms of suspended sentence in this matter.
He has 1 day or almost 2 days credit.
Thank you. Court will impose 2 days in jail, credit for 2 days served, and will indicate that the file is to close upon completion of those 2 days in custody. And the court has signed that order. Mr. Few, thank you very much, sir. In all likelihood, unless there's something else holding you, you should be released later on today.
Thank you, sir.
Is Miss Jonah Tips?
I'm sorry, this is, oh, thank you. You are Jonah Tips?
Donna, yeah.
Jonna, good morning. This is 24L001066. This matter is before the court for a first pretrial conference. Ms. Horwath, it does appear that you are, well, actually, my docket is not clear on that. Are you attorney, is your firm attorney of record in this matter?
I believe we were appointed 4 days ago, or we should have been. I believe the court did make an appointment 4 days ago. If not, we certainly would like to be appointed.
It looks like your office was appointed at the initial arraignment on June 26, 2024. Looks like your firm did file a motion to withdraw on February 18th, 2025. So yeah, I don't believe your office has been reappointed at this point. And it appears this is the first appearance since the issuance of that warrant. I assume that at this point in time, Ms. Tips does continue to qualify. Is that accurate?
That is accurate. I'm sorry. I thought she was seen 4 days ago here, but if she has not been seen, yes, please appoint to our office. She does qualify. She has no housing.
The court will appoint Ms. Horwath's law office to represent Ms. Tips in this matter going forward. Yeah, Ms. Horwath, it appears that we last saw Ms. Tips for her arraignment on June 26, 2024. It looks like she failed to appear for a pretrial conference on August 1st, 2024, at which time a bench warrant was issued. That warrant has been remained outstanding until it was served 4 days ago on May 5th.
Understood. Your Honor, we do have a proposed resolution today. The parties are proposing a stipulated order of continuance. Ms. Tips has been in custody 4 days. She has been sober for 4 days and has seen things a bit different. So she is willing to try to do the requested conditions and save a conviction here. So she's gonna get an alcohol drug assessment. We're gonna help her with that. And do some recommended follow-up treatment we expect. I did go over the entire document with her. She understands the contractual nature that she's entering into with the city, and that though she's waiving her rights today to a jury trial, she also is aware what will happen if she does not comply.
Thank you very much. Ms. Tibbs, did you hear everything that Ms. Horwath just represented to the court on your behalf?
Yes.
Is that all correct?
Yes, sir.
Okay, I have in front of me a document that's entitled Stipulated Order of Continuance. Have you gone through this document in its entirety with Ms. Horwath?
Yes, sir.
Did she read it to you, or did you read it to yourself, or both?
She read it to me.
Okay, did she answer all of your questions?
Yes, sir.
You understand that this is essentially a contract that you're asking to enter into with the prosecution to resolve your case pre-trial. Is that your understanding?
Yes, sir.
And you do understand that by entering into this agreement with the prosecution, you're waiving a number of your constitutional rights, including your right to a speedy jury trial.
Yes, sir.
You understand that pursuant to this agreement, which looks like it's for a period of 12 months, you're agreeing to do a number of things, including appearing on time for all scheduled court hearings, having no criminal law violations, updating the court of any change in your mailing address. You've also agreed to undergo a substance abuse evaluation and file a copy of that evaluation with this court within 60 days and be enrolled in any recommended treatment within 90 days and file proof of compliance with that recommended treatment. If you do all of those things, the prosecutor has indicated that 12 months from now, he'll come back before the court and file a motion to dismiss your case. Is that your understanding of the agreement?
Yes, sir.
Okay, and have you and Ms. Horwath had a conversation about what would happen in the event that the court were to conclude at any time between now and a year from now that you had not complied with this agreement?
Yes, sir.
You understand that you're stipulating to the admissibility of the report of the arresting officer, and that would be the only evidence that the court would consider at a bench trial in determining whether or not you are guilty or not guilty of these 3 charges?
Yes, sir.
And you're willing to stipulate to the admissibility of that police report?
Yes, sir.
All right. Court is going to approve entry of this stipulated order of continuance agreement. The court is going to make a finding that based upon the record that Ms. Horwath has made, as well as the court's conversation with Ms. Tibbs, that she is entering into this SOC agreement with the prosecution knowingly, intelligently, and voluntarily, with an understanding of all of the rights that she is waiving, as well as her obligations under this agreement and the potential consequences she would face in the event that she failed to comply with this agreement. Because this is a 12-month stipulated order of continuance agreement, the court is setting a review hearing in 1 year that will be scheduled for May 14th, 2026 at 9 a.m. here at the Lakewood Municipal Court. If Ms. Tibbs is in full compliance with all of the terms and conditions of this agreement, her presence at that hearing is waived. If she is not in full compliance, or there is some question as to whether or not she has completed every aspect of this agreement, she will be required to appear in court in person for that hearing. Ms. Tibbs, that will conclude your hearing. We will get you a copy of this agreement. I will indicate on this order that you are to be released in this case. So unless something else is holding you, you should be released later on today.
Thank you, sir.
Thank you. Ms. Horwath, who is that you have with you downstairs?
This is Ashley Meter, our last case.
Thank you. And this matter comes before the court for a first pretrial conference. Ms. Horwath, how would you like to proceed with the first pretrial conference?
Thank you, Your Honor. We are asking the court to accept a change of plea today. I did go over the guilty plea statement with my client. She is aware of the city's recommendation, the power that the court holds over her, and her constitutional rights that she's waiving by proceeding this way. And any questions that the court still has of her, she's ready to answer.
Thank you very much. Good morning. Can you hear me okay?
Yes, I can.
You are Ashley Marie Meter, and it appears that you are 25 years of age and you completed the 10th grade. Is that correct?
Yes, sir.
Ms. Meter, I have in front of me a document entitled Statement of Defendant on Plea of Guilty. Have you reviewed this document in its entirety with your attorney?
Yes, sir. Yeah,
Did you read it yourself? Did she read it to you, or both?
both.
Okay. This indicates to me that you're asking to change your plea to the charge of theft in the third degree from not guilty to guilty. Is that correct? Okay. And if you had an opportunity to discuss what that crime is, what the elements of theft in the third degree are, and what the prosecutor would have to prove if the case went to trial with your attorney?
Yes, sir.
You understand what you're pleading guilty to?
Yes.
Paragraph 5 of this guilty plea form lists out a number of constitutional rights that you're giving up by entering a guilty plea. Have you reviewed all of those rights with your attorney?
Yes.
It appears that if I accept your guilty plea, the prosecution is going to be recommending a sentence of 4 days in jail and for the file to close. Is that your understanding of what the prosecutor is going to recommend?
Yes.
And you understand that's just a recommendation. The court is not required to follow it.
Yes, sir.
You understand the court can impose up to 364 days in jail and a $5,000 fine?
Yes, sir.
Paragraph 11 of this document asks you to state in your own words what it is you did that makes you guilty of the crime of theft in the third degree. That statement reads as follows. On August 31st, 2023 in Lakewood, Washington, I removed items from Target without paying for them. Is that a true and correct statement of what you did that makes you guilty of the crime of theft in the third degree? Okay. Ms. Meter, has anyone threatened you in any way or made any promises to you to get you to enter this guilty plea this morning?
No.
You're doing this of your own free will?
Yes, sir.
All right. I'm going to ask you at this time for the record, under case number 23L001282, to the charge of theft in the third degree, how do you plead at this time? Guilty or not guilty?
Guilty.
Court will accept Ms. Meter's plea of guilty at this time. The court is going to make a finding that Ms. Meter has entered that plea of guilty knowingly, intelligently, and voluntarily after having had an opportunity to consult with counsel. It does appear that she understands the elements of the crime of theft in the third degree, the potential consequences of her plea, and based upon her statement and her plea form, there is a factual basis to support acceptance of that guilty plea, and the court will do so at this time. Mr. Vinson, is there anything you would like to add regarding the prosecutor's recommendation concerning sentence in this matter?
No, Your Honor, this is a joint recommendation. Ask the court to follow.
Ms. Horwath?
That is agreed. Your Honor, I've had an opportunity to speak with Ms. Meter about her time in custody. It's been extremely impactful. She's looking at life through a different lens right now, and it's kind of scary to her, but also really exciting. She has 2 children that she really hasn't met. So she's ready to make a substantial change in her life, and she is thankful to have this case closed so that she can focus on herself.
Thank you. Ms. Meter, you have the right to make a statement to the court before the court imposes sentence. You do not have to say anything. I'm not going to hold it against you if you choose not to make a statement, but you do have that right. Is there anything you would like to tell the court before the court imposes sentence? Okay. The court has reviewed Ms. Meter's criminal history. The court does believe that based on the facts of this case, that the agreed recommendation of the parties is appropriate, and the court will follow that recommendation in all respects. Court's going to impose 4 days in the Pierce County Jail, credit for 4 days already served, and will indicate that Ms. Meter is to be released and that this matter is to close at this time. And the court has signed that judgment and sentence. Ms. Meter, good luck to you.
Thank you.
Thank you, Your Honor.
Ms. Horwath, there's one other matter, very quickly, and here comes Mr. Vincent, that I wanted to address. There was a review matter that was scheduled to be before the court this morning on the Pierce County Jail calendar. City of Lakewood versus Laurel Lee Hartlett, 23L001116. Mr. Hartlett was scheduled to be before the court for a review following a plea of guilty to assault in the 4th degree domestic violence and criminal trespass in the 1st degree. However, Mr. Hartlett was recently sentenced in Superior Court to 40 months in the Department of Corrections and has been sent to Shelton from the Pierce County Jail. It is the court's intention to close this matter at this time. Is there any objection from either party?
From the city, Your Honor.
Thank you. That matter will be closed and the court will cease all jurisdiction. Thank you both very much. That will conclude the Pierce County calendar at this time.
Thank you, Your Honor. Thank you, Ms. Horwath. Have a good day.
And I think we have 2 more matters. One is Ms. Arnold's matter and one is Mr. Rusnick's matter. So we'll see who comes in first. Good afternoon in the Nisqually Jail. What is your name, please?
Mr. Mayor, how do I, it says join, do I hit that button?
Oh, that must be an error. Do not hit that button. We don't need a breakout room, Your Honor. This is Miss Powell.
Oh, perfect. Thank you. So you are Tamara Javoria Powell?
Yes, sir.
And your date of birth is August 1st, 1980?
Yes, sir.
Ms. Powell, good afternoon. This is case 25L000016, which is before the court for a review hearing. There is also 25L000567, which is before the court for an arraignment on a charge of theft in the 3rd degree. Ms. Arnold, are you prepared to proceed with the arraignment for Ms. Powell at this time?
I am, Your Honor. This is Sophia Arnold for the record. Defense will waive a formal reading of the criminal complaint and ask the court to enter a plea of not guilty on her behalf and stipulate to probable cause for today only. After screening her, she does qualify and we're asking for appointment without a promissory note as she is a student and is not employed.
Thank you. Ms. Powell, at this time on the new case, the court is going to waive formal reading of the criminal complaint, find that there is probable cause to support the filing of the charge of theft in the 3rd degree, and enter a plea for you of not guilty as requested by Ms. Arnold. Court will next hear from Mr. Vinson, the prosecutor, regarding his recommendation on pretrial conditions of release in this case. Mr. Vinson.
This relates to a theft from Michael's for $108 approximately. The city notes that the defendant has 33 past warrants, 13 of which were for theft. There is 1 active warrant from a case from 2012. Therefore, the city believes that bail is warranted but defers to the court as to the amount.
Thank you. Ms. Arnold, your response, please.
Yes, Your Honor. Defense is going to request that the defendant be released on her promise to return. We do recognize the warrant history. However, the most recent one from this year, she states that it was an honest mistake and she got the 2 dates mixed up. And we'd like to also make the court aware that she is a single mother that cares for a 6-year-old son. And she is the only one that can care for him in the area as her family isn't around. She has a way to get to court. She actually has 2 different bus passes, and the 2 of us did speak about a plan moving forward, calling us a week prior and confirming that court date so she doesn't have any more failure to appears. We're asking for 1 more chance in 2025 to allow her to return on her promise to return.
The court is concerned. The last time the court saw Ms. Powell, it was on case number ending in 0016 that is before the court for a review today. There was a failure to appear in that matter for arraignment. And then when Ms. Powell did appear for arraignment, she was in custody, and at arraignment entered a plea of guilty. Court imposed a 12-month suspended sentence on January 29th, 2025. One of the conditions was law-abiding behavior. And appearance at future hearings. A review matter was scheduled on April 1st, 2025 to review whether or not Ms. Powell had done the consumer awareness course that was required to be done within 60 days and performed 15 hours of community service. It appears that Ms. Powell failed to appear for that the first review hearing, and a warrant was issued for her arrest in the amount of $5,000. That warrant has remained outstanding until it was served at the time of her arrest. Appears 2 days ago when the warrant was served.
I just want to say, sir, I got the dates mixed up. Sorry.
Yes, Ms. Powell, I just want to make sure you run things through me before you state it on the record because it can be used against you. But I believe she was just going to say the same thing as I had previously mentioned.
That's the only reason why I missed her. I'm a single mother and I take care of my son by myself. I have to get him to school by bus, get him home by bus, public transportation. And then I have to make his appointments during the day because right now Bentley has seizures. So I have to make his appointments during the day and get back to pick him up by school by 3:30. So I have a lot on my plate right now, sir. And I'm not trying to make any excuses or anything. I'm just trying to let you know what's going on in my life right now. I'm not trying to miss anything. I actually am trying to rectify everything and get everything taken care of and done. Because right now it really is taken from my son and his medical needs right now. So I'm just trying to get everything taken care of so I can actually properly take care of my son and be a functioning member of society, sir. I got my school, I've got a job coming up, my son, like I got a lot riding on, me being, good. So I'm really sorry. I did just get the dates mixed up, sir. That's the only thing that's going on. And with the community service, the lady told me that she's waiting for my name to come up on the list. I have Eloise's kitchen, which is by my house, but I'm just waiting for her to come up with a date for me because I don't have the transportation but the bus. So that's the closest place for me to do my community service, which is, a good deal for me because it's not that far. I'm just waiting for her to have a slot for me to do it. And with the consumer awareness class, I told them when they gave it to me that I'm not making a lot of money right now, so I might not be able to afford it. So I'm just honest and tell you what's going on, sir.
Yeah, and Ms. Powell, I appreciate that information. I appreciate your responsibilities as a mother. That makes a huge difference to the court. I want you to understand where I'm coming from. The court saw you not too long ago and imposed certain conditions. A big one was you've got to show up in person and on time for all of your court hearings, and you didn't do that. So it places me in hold on, let me finish. It places me in a very difficult position because I want to give you the benefit of the doubt. But when I look at the history of these two cases, you're not keeping up your end of the bargain. You're not showing up for court when you're supposed to. Now I'm going to give you one more chance. I'm going to release you today, but I want to be really clear with you. If you fail to appear for any future hearings going forward in these two cases, the court is likely going to issue a warrant for your arrest and is likely going to hold you in custody on bail.
You don't have to worry about that. I will be here.
Okay. The other thing I'm going to tell you is I understand, especially with a 6-year-old, that life happens.
Yes.
And if something comes up, I get it. What I don't get is why you haven't called your attorney and said, something just came up. Can you please let the court know this is what's going on? Because I'll tell you, Ms. Arnold and her colleagues are very good at letting me know Judge, my client's not here, but let me tell you why. And I spoke to my client earlier today, and this is what's going on. We're asking you to continue the case and not issue a warrant. And 9 times out of 10, I agree to that. But they can't tell me that if you don't contact them and let them know. So the court's going to go ahead and release you on your personal recognizance, but I'm going to impose a number of conditions on you. Number 1, you have to appear in person and on time for all scheduled court hearings. Your next hearing in this case is going to be on Thursday, May 29th at 2 o'clock in the afternoon. The other thing the court's going to do, and this is a really, really important one, the court is going to appoint the Horwath Law Offices, that's Ms. Arnold's law firm, to represent you on the new case. They're already your attorney on the old case, so they're already on that case. Their contact information, including the telephone number for their office, is going to appear on your paperwork. Save that in your cell phone. Okay, save that in your cell phone. So if something comes up and for whatever reason you're going to be late or you're not going to make it to court, call your attorneys and let them know. You can call the office and then the office will communicate with the attorneys even if they're in court at the time. So you make sure you're remaining in contact with your attorneys. Have no criminal law violations. Update the court of any change in your mailing address. Because you are alleged to have committed a crime with the Michaels store in Lakewood, I am prohibiting you from going back to Michaels until this matter is resolved, okay? And the court has signed that order. Ms. Powell, we will see you back here on May 29th at 2 p.m. You should be released later on today. Do you have any questions at all about the conditions?
No, sir. Thank you. Thank
All
you.
right. You're welcome. We'll see you back here on May 29th at 2 p.m.
All right, thank you.
And I believe that is my last case, if I could be excused.
You are excused, Ms. Arnold. Thank you. Have a nice weekend.
Have a good weekend, y'all.
Good morning or good afternoon. Are you Aisha Jadam Anderson?
Yes, sir.
I apologize.
Okay.
Good afternoon. You are before the court for a review hearing. Your attorney, Mr. Rusnick, is also on the Zoom platform with us. This is case 23L000589. This matter, as I mentioned, comes before the court for a review. Ms. Anderson entered a plea of guilty to 1 count of assault in the 4th degree domestic violence on June 17th, 2024. This matter is before the court for a review following a failure to appear for a review hearing and a bench warrant being issued. The issues that the court see as outstanding are there were community service hours that were ordered, there was anger management that was ordered, and there was attendance at a domestic violence victims impact panel that was ordered. All of those are conditions of suspended sentence. The court's review of the calendar indicates that those conditions, unfortunately, still have not been complied with. But I will give Mr. Rusnick an opportunity to speak to that. Mr. Rusnick?
Looking at her history, including some subsequent violations, including warrant history and outstanding warrants in different jurisdictions, I think Ms. Anderson would welcome a nominal sanction and close these cases. It seems like she's a moving target and maybe homeless for all I know, as far as coming back and complying. I don't think it's necessarily an unwillingness, but an inability, or maybe 90% inability and 10% unwillingness to comply with conditions. But the point being, I think she would like some nominal sanction imposed, and then upon serving the sanction, close out this case and give her some repose.
Mr. Vinson?
Normally, Your Honor, the city would concur with Mr. Rusnick's recommendation. However, the city is concerned that this was an underlying offense, was a domestic violence assault, and the conditions that she was required to perform were to benefit her, but also to benefit the community. Normally, domestic violence charges have a jurisdiction of 5 years. There's still an active no contact order, so the city would not be comfortable imposing and closing this matter without further notice and discussion with the victim in this matter.
Okay. Mr. Resnick, as a threshold matter, is your client stipulating to the violations, the failure to complete community service, anger management, and the domestic violence victims impact panel?
Yes.
Okay. Or we'll accept that stipulation. We'll find that violation.
I don't know where to go.
So, yeah, I get what both attorneys are saying. Mr. Vincent has a valid point. This matter was only before the court for change of plea less than a year ago, and the court still has over 4 years of jurisdiction that was taken. But Mr. Resnick is right. It looks like there are a lot of other things going on in other courts that are spreading Ms. Anderson pretty thin. I see that there are warrants outstanding out of Spokane Municipal Court. There is a warrant out of Yelm Municipal Court, and there's a warrant out of Pierce County District Court. So, you know, Ms. Anderson has a lot on her plate at this point, and I guess I'm struggling with what the court is hoping to accomplish by continuing to maintain jurisdiction in this case. I agree with Mr. Vincent. I think the anger management, with the domestic violence victims impact panel would absolutely be beneficial for Ms. Anderson, and the community service hours that she agreed to do would be beneficial for the community. What was that?
Oh, I'm sorry, Your Honor. I just said I've been doing community service, but they didn't have any openings at the St. Vincent de Paul, so I just picked garbage up everywhere I go. I'm picking garbage up, and I was hoping maybe I can get signatures from businesses and the people that work there to prove that I've been doing so. As far as getting to Yelm, I couldn't get there. I don't have a car. I didn't have a phone. I just recently obtained the free phone again, so I had to wait 30, 60 days in order to get a phone through that service. Now I have it. I tried calling, was subsequently unable to do so, but getting there was the main problem. I have no problem being in compliance with any factor of what needs to be done to be able to get to these court dates, but I can't go to Spokane if I'm not supposed to leave jurisdiction. I can't, you know what I mean? I didn't even know I had a warrant out for that, for the domestic violence between my son and I haven't spoke with my son at all, which is, I'm sorry, which is killing me in and of itself.
You're okay, Ms. Anderson. You're okay. All right. Here's what the court's going to do, and I don't really like it, but I think I'm persuaded more by the argument and the position of Mr. Resnick. It's not to say that there isn't value in what is being proposed by Mr. Vincent, but I feel like at this point we continuing to require Ms. Anderson to do those affirmative conditions is just frankly setting her up for failure. The court is not going to close this case. However, what the court is going to do, the court's going to waive the previously imposed conditions of the anger management, the domestic violence victims impact panel, as well as the community service hours, the anger management, community service hours, and domestic violence victims impact panel. So the court is waiving all of those affirmative conditions at this point in time. The court will maintain jurisdiction at this point for law-abiding behavior, and will also maintain the outstanding no contact order that was issued as a condition of sentence, because Mr. Vincent is right. I'm not going to recall that no contact order unless there's been notice to the victim, and there hasn't been. So the court is going to go ahead and accept the stipulation find that there is those violations for failure to comply with the terms and conditions of suspended sentence. Court is going to impose a sanction. I do think that's appropriate. Court will impose 20 days in jail and give Ms. Anderson credit for the time that she has already served. It looks like she was booked in on May 8th. So she's entitled to 1 day credit. She'll have 19 days to go. I'll indicate that jail term is to run concurrently with any other commitments.
Is there any way to do an ankle monitor at New Life instead of being in jail?
Ms. Anderson, unfortunately, no. For the very same reason that I'm waiving those affirmative conditions, I think you've got a lot of stuff going on here, and my concern is that any condition I impose upon you is going to set you up for a potential violation, which is only going to make the hole that you're in deeper. So the court is going to go ahead and impose that 20 days in custody. I'm not going to set any future reviews at this point in time. But that will be the sanction of the court. And you should be released probably in about, I'm guessing, probably about 2 weeks. And then at that point in time, it looks like you've got some outstanding warrants that you're going to have to address in other courts. So I'm going to, for all intents and purposes, get this case out of the way and let you deal with those.
Thank you, sir.
Court has signed that order. That will conclude Ms. Anderson's hearing. Is there anything else from either attorneys that we need to address before court is at recess?
No, Your Honor.
No, Your Honor.
Thank you all very much. Have a nice weekend.
Thank you.
Thank you.
Oh, ladies and gentlemen, that's the end of the Lakewood docket, and we're on to Judge Ricky. It starts right now.
This is the Butler County, Kansas first appearance docket of May 9, 2025. I'm David A. Ricky, District Judge. The first case that the court will call is State of Kansas versus Zachary Daniel Irvin. Mr. Irvin, is that you at the detention center Zoom location?
Yes, sir.
Jared Regier appears for the State of Kansas. Mr. Irvin, this is 2025 CR 209, and in that case, you are charged with domestic battery, a Class B person misdemeanor, generally punishable by up to 6 months in the county jail and up to a $1,000 fine or both. How do you intend to plead to that charge?
Not guilty.
Court will accept the plea of not guilty and will set an appropriate date. Can you afford to hire your own lawyer on this?
Yes, sir.
All right.
Okay.
Go ahead.
I have an active job, a towing and recovery job. I'm the only one that pays any of our bills right now for the household, even though I know things have gotten crazy with Laura and everything, but I'm the only one that has the job in the house. I'm the sole provider for all of our income, all the food and everything. And I did not know if there was a possibility of bond for this. I could not go to the house. I have a camper that I own that I can move to a totally different town. I
thought we were on the subject of you being able to afford an attorney.
Oh, sorry. I'm sorry.
Okay, so
Sorry,
one
sir.
step at a time here.
Okay. Yes, sir. I'm sorry.
All right, I'm going to presuppose then you're going to have the financial resources to have an attorney with you at the next court date I'm going to set. That's going to be set with Judge Webster on July 21 at 9:00 a.m. That'll be a Zoom docket. You must be fully on that meeting with Judge Webster on July 21st, 9:00 a.m.
Yes, sir.
What is your recommendation regarding bond here, Mr. Regier?
Your Honor, in this matter, the state is recommending a strict no contact order as well as GPS monitoring. This is with a cash or surety bond in the amount of $7,500. This is depending who the state understands has multiple assault convictions out of other jurisdictions well outside the state of Kansas. It would appear that pursuant to page 2 of the affidavit, there were references to similar incidents out of the state of Texas. Additionally, it would also appear that multiple marks on the victim's face were observed by law enforcement. Therefore, the state is recommending that 7,500 cash or surety, all standard conditions, GPS monitoring, and a strict no contact order with the victim are appropriate.
You say 7,500?
That is the state's recommendation, Your Honor.
Anything you want to say in response, Mr. Irvin? I'm a little disturbed about maybe a history of domestic violence here.
Yes. So the last one, I walked by and knocked a plastic cover off of a mirror. And the first one was
Okay,
an
all right.
alcohol incident
All right.
that we had in Texas. This last one was also an alcohol involved incident, but I had not been drinking.
Let me stop you there. Let me tell you what my concern is, that if you get out on bond, you're going to go around her and you're going to bother her again.
Oh, no, sir.
That cannot
No,
happen.
sir. No, sir. I will. You can, the supervision, I'll wear an ankle monitor, whatever you need me to do, but I will not go anywhere near her for any reason. I just can't lose my job. That's my biggest thing. I just have to be able to go to work.
I'm going to set bond in this case at $1,000. Cash or a professional surety required. I'm going to decline to order GPS monitoring in this case. Mr. Irvin, what you need to do is obtain a separate residence, stay away from the alleged victim in this case, LLC. You know who I'm talking about.
Yes, sir.
No contact, no communication, can't be in the same place with her at any time. And I wouldn't violate this condition if I were you.
Yes, sir.
You're going to be spending an awful long time in jail just waiting for your case to be over with.
Okay. Yes, sir. I understand. And I appreciate the bond reduction and the fact that I can even get bond. I appreciate that so much.
1,000 cash or professional surety required, no contact with the victim. Appear for all scheduled court dates, including the one that we've set, July 21st at 9:00 a.m. And again, the GPS request by the state is denied at this time.
Yes,
I
sir.
want you just out there working as many hours as you can and staying
Yes,
out of
sir.
trouble.
I travel I'm a truck driver. I travel, so I'll just stay in the truck.
There you go.
And I
Don't
appreciate
forget about your court date.
Yes, sir.
And you do need to make sure that attorney's on board in time to be appearing with you at your next scheduled appearance. All right?
Absolutely. Yes, sir.
Sooner you get a lawyer on board, the better.
Yes, sir. Thank you.
Very well. The Zachary Irvin matter will be in recess at this time. We'll move on to the next case.
Thank you, sir. I get it.
Daniel Hinman?
Dakota Hinman?
Dakota, excuse me, Dakota.
Yes,
All
sir.
right. This is State of Kansas versus Dakota Ray Hinman. It's case number 2025 CR 210. Jared Regier appearing for the state. Mr. Hinman from the jail Zoom location. Mr. Hinman, do you have a copy of your charging document before you?
Yes, sir. Yes, sir.
Count 1, alleges theft, a level 9 non-person felony. Count 2, expired tag or registration, an unclassified non-person misdemeanor. Count 3, no proof of insurance, a class B non-person misdemeanor. A felony is involved. You will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield.
What would you say count 3 was? I only got 1 and 2. Sorry.
It's on a separate page.
I can get them to you. Okay.
Count 3 is no proof of insurance.
Okay. I got a question. As far as this like theft on this car, we got video of dude like literally signing a bill of sale. I mean, everything was done right there at his house 3 weeks ago, and I just got pulled over in the car last Monday, and they
We're
ran
not going to get into the facts
Okay,
of
okay.
supporting guilt or innocence at this time. I just have the charge before me. I'm just trying to inform you what those charges are.
Yes, sir.
Can you afford to hire your own lawyer to represent you on this?
Not right now, no.
Okay, I'm going to enter a plea, not a plea at this time. I'm going to go ahead and make a preliminary hearing scheduling before Judge Satterfield, which will be July the 14th, 2025, 2:30 p.m. You must fully and personally appear and participate in Judge Satterfield's docket at that time, July 14th, 2:30 p.m. I'm going to require you to appear at the Butler County Judicial Center in El Dorado, Kansas for that appearance if you make bond, Mr. Hinman.
Okay, what is my bond?
Well, we're going to talk about that here in a little bit.
Okay.
Regarding an attorney, Mr. Hinman, what's your financial situation currently?
I am employed. I don't know. I don't got that much like saved up to put it down deposit. I mean, depending on what his retaining fee is, I may be able to get an attorney. I haven't even.
It's going to be pretty high.
I mean, the charges changed. I thought there was different charges than this. This is the first time I've seen these charges. Everybody keeps telling me there's something else. So
Okay. I'm going to go ahead and find him partially indigent, and we'll appoint a lawyer to represent him. James Watts will be appointed. Recommendation regarding bond here, Mr. Regier.
Your Honor, the state's understanding is this is a case where pursuant to page 2 of the affidavit, the vehicle is alleged to have been stolen from a location in Sedgwick County. This is the defendant who the state understands would be considered a B on the grid under Kansas law. The state's understanding is this is a defendant with few, if any, ties to Butler County, so the state does consider this defendant a flight risk, as well as the defendant's prior failure to appear at least 4 times. State further understands this is a defendant with a history of traffic and property-related convictions and adjudications, including at least 1 conviction for aggravated robbery and 1 adjudication for felony burglary. For those reasons, the state is recommending all center conditions, no contact with any co-defendants, as well as bond in the amount of $7,500 cash or surety.
Do we have co-defendants on this docket, Mr. Regier?
I believe so, Your Honor.
One's my wife.
Mr. Regier, I need him to answer. I'm sorry.
I believe so, Your Honor.
Okay, and who would that be?
Your Honor, the information appears to refer to multiple individuals, last names Vo, Thomas, and Rakes.
Rakes is my wife. I don't know.
All right. Okay. Court will set bond in this case at $7,500 cash or professional surety required. There are a number of concerns which caused the court to enter a bond that high, including criminal history of this defendant, a record of failure to appear. Among them, the court does set bond at $7,500 cash or professional surety with a no contact restriction with super car guys, the alleged victim in this case, or their property, or any of the co-defendants in this case. You wanted to be heard on that, Mr. Hinman?
Yeah, my wife is Rakes, Tori. So
why does she not have the same name as you then?
It's in your guys', well, not in your court, but it's in the courts right now. We just did it 2-3 weeks ago. The marriage license and all that shit. Like we've been together since high school. I don't got no reason to lie to you, sir. I just didn't know how that would work. Like, cause she's gonna bond out. I'm sure she's gonna try and bond me out. But he said I can't have no contact with her. I live with her. Like we live at her parents.
Do you have children together?
No, sir.
The court's currently going to follow the state's recommendation regarding no contact with any of the co-defendants at this time. You can ask your assigned judge, Judge Satterfield, for relief on that at some point in the future. I think it's better that you not have any contact with Tori Rakes, Sierra Thomas, or Fung Van Vo, who the state identified as co-defendants in your case. And that will be a condition of your bond, Mr. Hinman.
Okay.
All right, so we've got our court date set. Judge Satterfield, July 14 at 2:30. Defendant to appear at the Judicial Center, $7,500 bond with no contact restrictions. And James Watts appointed as counsel. Anything else we need to cover here, Mr. Regier?
Not to my knowledge, Judge.
Very well. Then the Hinman matter will be in recess.
Okay, so
Yeah.
Right, another individual's been seated at the jail Zoom location. Your name?
Titan Bar.
Okay. At this time, the court calls case number 2024 TR 2027, State of Kansas versus Titan and Far, or M. Far, also known as Titan Kellogg. The defendant appears at the jail Zoom location, Jared Regier, on behalf of the state. I see a failure to appear warrant. I'm just trying to determine, Mr. Regier, perhaps you can assist. What documentation is before this court that this individual was actually served with the warrant? Or excuse me, the summons or alias summons?
One moment, Your Honor.
Yeah, her incarcerated status doesn't make it obvious she was served eventually with the warrant.
I was not served with a warrant.
Your Honor, the state's understanding, based off my notes, is that this matter previously came before the court before Judge Webster on March 19th. The state advised the court that there was a return on the summons indicating unsuccessful service as of March 19th of 2025. The state further advised the court as to the filing of an alias summons on March 14th of 2025, but at the time, based off my notes, there was not a return of service on file with the court in this case. At that time, the court determined that bench warrant on its own was appropriate.
Bench warrant or a probable cause arrest warrant? Bench warrant is normally issued for failure to appear, but if she was never served with the paperwork.
There does appear to be such a document on file with the court dated March 21st of 2025, Your Honor.
Well, I note that, and I'm concerned about it. All right, let me address the defendant. You said that you weren't picked up on a warrant?
No, they just pulled us over and said that I had a warrant. That's all they told me.
Okay, so you were arrested on the warrant.
Apparently, yes.
All right.
But
My question is whether you should have been or not.
Yes.
All right. The state did have the option of seeking a probable cause arrest warrant on you when they couldn't get you served with a summons. I don't know why you've been so elusive and hard to find.
I don't either.
But let's deal with the fact that you've got some charges pending in this court. Count one of the alias summons would indicate they're prosecuting speeding, 81 and a 55, an infraction in count one. Count two, driver's view obstructed by load or passengers, an unclassified misdemeanor. Count three, no valid driver's license, a Class B misdemeanor. How do you plead to these charges?
I plead guilty.
To all three?
Yes.
And you want to waive the assistance and advice of legal counsel in doing so?
Yes, I believe so.
And even though that if you can't afford one would be appointed for you?
Yes, I understand that.
All right. And you want to waive counsel? If so, there's a form that I think they can put in front of you that you need to consider before we can go any further with this.
Okay.
So if we have a waiver of counsel form, if we could place it before the defendant?
Yes.
If you have any trouble reading it, let the court know.
Okay. Okay. Thank you.
Does it appear that the defendant is signing a waiver of counsel form at this time?
Yes. Do I just put the date here? Yeah. What is the date?
May 9th.
Thank you. Oh, shoot. May, right? Okay, thank you, sorry.
Has the defendant signed the form?
Yes, sir.
Thank you. All right, it appears that you waived counsel and it is your intention to enter a guilty plea to these charges?
Yes.
All right. So you're acknowledging to the court that on July 29 of 2024, You were speeding 81 and a 55.
Yes.
Currently driving a vehicle with the driver's view obstructed by load or passengers. And not having a valid driver's license in your possession, correct?
Yes, correct.
You do understand that an infraction is punishable by up to a $500 fine. Non-person misdemeanors, 30 days in jail and a $500 fine are possible.
Yes.
And a Class B misdemeanor is punishable by up to 6 months in the county jail and up to a $1,000 fine or both. You understand these things?
Yes, I do.
Okay. And so, do you freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for these 3 charges?
Yes, I do.
Court will accept the defendant's pleas to the infraction in count 1 and the misdemeanors in count 2, finding that this is a free and voluntary act on her part, that she's waived counsel here on the record, and she's been made aware of the possible penalties. There does appear to be a factual basis supporting each of the charges. Court will accept the defendant's pleas and find her guilty of all 3 offenses. We'll turn to sentencing at this time. What does the state recommend, Mr. Regier?
Your Honor, for count 1, the speeding, the state is recommending the scheduled fine, which the state understands that pursuant to statute is $159 as well as $108 court cost. For count 2, the state is recommending a $100 fine. The state will defer to the court to make a ruling as to whether or not an underlying sentence is appropriate. For count 3, the state is recommending a $100 fine with a 6-month underlying sentence, subject to 6 months of non-reporting probation.
All right, I'll call you Ms. Kellogg because that's what's on my paperwork.
Okay.
How long have you been in custody?
Couple of days now since this is Friday. Since
I
Wednesday.
thought you would know right down to the minute or even second how long you've been in the jail.
Since Wednesday.
Okay. All right, fair enough. Do you have any statements that you wish to make in mitigation of punishment here?
No, I do not.
Where do you live?
I live in Stafford right now.
Are you working currently?
No, sir, I am not.
How do you make a living? How do you survive financially?
I don't.
Okay. Somehow you find money for food and shelter, I presume?
I food stamps and yeah, food stamps.
Anything else you want to say in mitigation of punishment here?
No, sir, I don't.
Right.
Is there a way that I can bond out or? I mean,
Well,
if
you're
somebody
not
else
gonna
bonds
bond
me
out.
out. Uh-huh.
Okay.
Gotcha.
For count 1,
Mm-hmm.
for the conviction of speeding and infraction, the court will impose a fine of $159,
Okay.
court costs of $108.
Okay.
On count 2, driver's view obstructed by load or passengers, an unclassified misdemeanor,
Mm-hmm.
10 days in jail, $10 fine.
Mm-hmm.
Count 3, no valid driver's license to Class B, non-person misdemeanor. The court imposes 10 days in jail. Consecutive to count 2, $10 fine.
Mm-hmm.
Court's taken into account the limited financial resources of this defendant. It would appear then that you've been assessed $179 in fines, and $108 in court costs. Given your financial circumstances, when can you commit to having this paid?
My fiance is supposed to be paying it today if he can get me out. Yeah.
Right. You've also received 20 days in jail. I would ask the county attorney's office to confirm how many days she's been in custody and grant that jail time credit in the journal entry stemming from today. I will grant her at this point 6 months of non-reporting probation. You know, if you're in a position or your fiance is in a position to pay this off, it's in your best interest to do that.
Yes, he's supposed to be paying it off today, once he finds out how much it is. So if he pays it out, I can get out today?
Yes?
Okay, thank you. That's what
Actually, I'm going to release you anyway.
Okay, thank you.
I don't want to make it look like that we're extorting the fines from you to get out of jail. I've placed you on probation in this case.
Okay,
All right? You
and
need to
probation means
serve
what?
all laws, and you need to get this paid.
Yes, sir.
You've indicated to the court that you have the resources, or your fiance does,
Yes,
to
sir.
take care of this. So take care of it.
Yes, sir. Not a problem.
Well, look, you've done a couple of days in jail over this. You shouldn't have.
Yes, sir.
But the reality is, that's an implication of a criminal case pending and you not taking care of it. So if you take care of it by paying the fines, I'll discharge you from the non-reporting probation.
All right.
Okay?
Yes, sir.
So that will be essentially an act of case termination once you get this paid.
Okay.
All right. Otherwise, you've got, looks like about 18 more days of jail time hanging over your head if you don't take care of it.
Yes, sir.
All right. I just hope he can get it all paid today and you can be done with this.
Yes, sir.
Okay, you're going to have to wait until the jail can process you out.
Okay.
Be patient with them. They'll get to it as soon as they can.
Not a
But I'm gonna
problem.
order you released at this time on this hold. If you've
Okay.
got other holds on you, I'm not releasing you from those. Okay?
Yes, sir.
Is this the only thing you're in jail for?
Far as I know, yes, sir.
Okay.
I hope so. I know,
I hope so too.
right?
Your Honor, if I may.
Yes, I do note that there is, I'm going to move to the other matter. You were picked up on possession of opiate and possession of paraphernalia charges. At this point, the state is not filing on you.
Okay.
So I'm not going to hold you any longer on that.
All right.
I need to have some very definite address information in case they review the case and file charges in the future.
It's 218 North Boston in Stafford, Kansas.
218 North Boston, like
Yes,
in
sir.
the city in Massachusetts?
Yeah.
All right. Do you expect that to change in the foreseeable future?
No, sir.
All right, because if they file charges, and it's highly likely that they will,
Yes,
they'll
sir.
send a summons and they'll have it served at that address. And
Okay.
if you get it, you just come back to court whenever it tells you to.
Yes, sir. Not a problem.
Because if they can't get you served or you don't show up, another arrest warrant will issue.
Yes, I understand.
Okay, so make sure you appear in court when the summons that you would eventually receive reaches
Yes,
you,
sir.
right?
Okay. Yes, sir.
All right, Mr. Regier, is there anything else on this
Honor?
individual that I need to address currently?
Yes, Your Honor. In the case that proceeded to sentencing today, does the court wish the journal entry to reflect that the case shall be paid in full by close of business today?
Yes, hopefully, yes.
Well, I don't know about hopefully, because you're not the one.
Yes, yes, it should be, yes, yes. Yes,
Yes, Mr. Regier.
Thank you, Your Honor.
sorry.
Yeah, it's definitely in your best interest to get this done.
Yes, ma'am. Yes,
Okay.
sir.
Good luck to you in the future.
Thank you. I appreciate it.
Okay, I'm ready for someone else, a Tory Rakes, perhaps?
Your Honor. Your Honor, my name's Noah Moore. I'm at work right now, and I was wondering if it'd be possible that I could get kind of front run so I can get back out there. I didn't know how long this would take, but my boss is allowing me a little bit of time to just take care of this. I just want to know if it's possible. If not, I can go let him know.
Well, there were days not too long ago where you had to come to the courthouse in El Dorado for this appearance. That would have taken you a lot more time.
Oh, I understand. I'm getting a lot of grace on either side. I just figured I would ask so I can just give my boss an answer.
I'm going to take up State of Kansas versus Noah Moore at this time.
Thank you, sir.
2025 CR 60. Jared Regier appearing for the state. Mr. Moore on his own Zoom. Do you have a copy of your charges?
I do not.
You are charged in count 1 with possession of cocaine, a level 5 drug felony. Since it's a felony, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before this court. This court's next date for that purpose is June 2, 2025 at 2:30 p.m.
June 2nd?
Yes,
Yes, sir.
2:30 p.m. I'm
Let
going
me
to
write
order
that
you to
down.
appear, Mr. Moore, at the Butler County Judicial Center in El Dorado for your next court date.
Okay.
June 2nd, 2:30, Butler County Judicial Center, El Dorado, Kansas. Can you
May
afford to
I
hire
please
your lawyer?
request counsel? Yes, can I request counsel, please? I cannot afford it.
You're working, but you can't afford an attorney?
No, I'm a server and I work 3 days a week right now at Luciano's in Mulvane. So I don't make a whole lot. I'm getting back on my feet after my history would show that I had some history of not doing so great. And I'm trying to just kind of fix all that right now.
All right. I'm going to find the defendant partially indigent and appoint James Watts to represent him. What's the recommendation regarding a bond here, Mr. Regier?
Your Honor, besides all standard conditions, given the level and nature of the charge currently before the court, the state is not opposed to a $5,000 bond. The state is, nor is the state opposed to an OR bond, given the fact that the defendant appears in the fashion that he does today. This is a defendant with some recent history of failing to appear at least 3 times, most recently in September of 2024, as well as at least 1 prior conviction for misdemeanor DUI.
We'll set bond in this case at $5,000 OR. We'll require Mr. Moore to appear for any and all court appearances on time.
Yes, sir.
Mr. Moore, if you don't show up for one of this court's court dates, you're going to be introduced to a term called no bond hold,
Yes,
which
sir.
means you sit in jail until your case is over.
That would be terrible because like
Well,
I said,
that cannot happen, and you need to make sure you just appear for every court date when scheduled to do so.
Yes, sir. I appreciate the grace. Like I said, I will fully admit I was in a pretty effed up position on myself. So I just want to fix all this.
All right. You're going to need to get processed on this bond.
Okay.
I have court security 1 on this meeting. What do you recommend here?
Just be in a breakout room with him, Your Honor, and I can get him set up.
Mr. Moore, you're going to need to stay with the meeting a little bit longer. You're going to meet with one of our security officers with the sheriff's department. He's going to give you instructions on how to get processed on this OR bond.
Yes, sir. What does OR mean?
It means own recognizance, which means that you don't have to put up money at this stage.
Thank you, sir.
But it's a promise that you're going to owe that if you don't show up.
Yes, sir. Can do.
All right. So stay. We're going to put you and he in a breakout session, and then you can go back to work.
Thank you, sir. Appreciate you.
All right. There's nothing further. The Noah Moore matter will be in recess, and they can go to the breakout session at this time, Andy. I'm presuming while I was dealing with Mr. Moore out of turn there, that Tori Rakes came in. Is that yes? If we could get her audio back on. Tori?
Yes.
Okay. I have information, Tori Marie Rakes, that you were brought in on possession of an opiate suspicion. However, the state is not filing on you today. I'll also make you aware that I believe it was Mr. Dakota Hinman that was in here earlier. He's under a no contact restriction. He's not to have any contact with you at this current time. Just making you aware of that.
Okay.
Where are you going to be living if you get out, Ms. Rakes?
I'm sorry, what?
Where are you going to live?
In Altamont, Kansas, at my parents.
Do they have addresses in Altamont?
Yeah, 1678 15,000 Road.
Okay, go real slow.
1678 15,000 Road.
Okay, Altamont, Kansas.
Yes.
Okay. All right, if the state decides to file charges, they'll issue a summons. When you get that summons at this address you gave me in Altamont, you're going to need to respond appropriately to it.
Okay.
Because if you don't and they can't get you served, then an arrest warrant will issue and you'll be back in jail.
Okay.
Just make sure you show up in court when the summons tells you to, if
Okay.
they issue a summons, okay?
Okay.
If you have other holds on you, I'm not going to release you from those, but on this particular matter, I'm going to order you released at this time.
Okay. Thank you.
All right. Anything else, Mr. Regier?
No, Your Honor.
Okay, the Tori Marie Rakes matter will currently be in recess.
No.
Sierra Thomas.
Yes, sir.
This is State of Kansas versus Sierra Lynn Thomas. Case number 2025 CR 212. Sierra Thomas appears from the jail Zoom location. Jared Regier on behalf of the state. Ms. Thomas, you want to look up?
Yes, sir.
I have a charge before me of possession of methamphetamine, a level 5 drug felony. Since it's a felony, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Chad Crum. Judge Crum's next docket for that purpose would be June 16, 2025 at 2:30 p.m. You must fully participate in Judge Crum's docket at that time. June 16, 2:30 p.m., Judge Crum's court. Thomas, weren't you before this court not very long ago?
Yes, sir. Actually, I was before this court and I was set up to go to Kissa, the horse ranch, on the 14th of this month. Willingly, I wanted to go there, needed to go there. Still do need to go to treatment. I know I'm not pleading my case, but I didn't. This is not mine. I mean, it wasn't on me, my person. So.
All right. Again, Judge Crum will take up your case here next on June 16 at 2:30. Can you afford to hire a lawyer?
No.
Court will appoint James Watts. Second thought. Watts was appointed on Hinman, was he not?
That is the state's understanding, Your Honor.
Okay. Then I will appoint, who was your lawyer in your other case, Ms. Thomas?
The first case, sir?
Yes.
It was Christopher Ambrose. And if he could, I would love for him to take this case as well.
I will appoint Chris Ambrose to represent you.
Thank you.
Recommendation regarding a bond here, Mr. Regier.
Yes, Your Honor. While the state does not have the intimate details of any cases in other jurisdictions, the state understands that this is a defendant who was recently convicted of similar charges, misdemeanor possession of drug paraphernalia, as well as felony possession of opiates. For that reason, the state is recommending, besides no contact with illegal drugs and no contact with any co-defendants, a $3,500 cash or surety bond.
Anything you want to say about that, Ms. Thomas?
3,500, so that would be at 10%, or what's cash?
Generally what a bondsman charges as a fee, but that's between you and the bondsman.
Okay. Right, and I would keep no contact, yes. Sorry, I understand.
All right, the court will set bond at $3,500, cash or professional surety required. With a no contact restriction between this defendant and Dakota Hinman, Tory Rakes, and Fung Vang Vo. Need to find a new set of friends.
Yes, sir, I do. I just met them too, which is crazy. And if I bought my car through them, it's not too long ago. That's how I met them.
If you make this bond, I highly suggest you enter into the program that you had referred to earlier.
Yes.
It would appear to the court that you very well may need it.
Yes, sir.
All right. You remember that court date, Sierra?
June 16th. Is that correct?
Yes. What time?
At 2:30.
Okay, I'm gonna order you to appear, if you make this bond, at the Butler County Judicial Center in El Dorado, Kansas for your court date.
Okay, El Dorado? Okay.
Yes.
All right.
At the Judicial Center. I want you to appear from there.
Okay.
16th at 2:30. All right. Anything else, Mr. Regier?
From the state, Your Honor.
Very well. The Thomas matter will currently be in recess.
Thank you.
You Fung Tan Vo?
Yes, Your Honor.
This is the State of Kansas versus Fung Tan Vo. It's case number 2025 CR 211. Defendant appears from the Butler County Jail's Zoom location. Jared Regier appears for the state. Do you have a copy of your charging document before you? Let me inform you of your charges. Count 1 is possession of methamphetamine with the intent to distribute, a level 2 drug felony. Count 2, possession of methamphetamine, a level 5 drug felony. Count 3, possession of paraphernalia for use, class B misdemeanor. Felonies are involved. You will not be asked to plead at this time. Rather, you will be set for appearance before this court on June 2nd at 2:30 p.m. If you make the bond that we're going to talk about here in a minute, you need to appear at the Butler County Judicial Center in El Dorado for your next court appearance. And that would be June 2nd at 2:30. Can you afford to hire a lawyer?
No, Your Honor.
Take you at your word here. This is a very serious case. Court will appoint Chris Pate to represent you. Recommendation regarding a bond here, Mr. Regier.
Your Honor, as to reiterate what the court has already referred to, the state does consider this a very serious case. Besides no contact with any alleged co-defendants and no contact with drugs or alcohol, the state is recommending a high bond in the amount of at least $10,000 cash or surety. I believe the court has already addressed the level of the charges, especially with regard to count 1. Additionally, the state does consider this defendant a flight risk. The state understands this is a defendant with at least 9 prior failures to appear, most recently in September of 2023. Additionally, the defendant has a somewhat interesting criminal history. The court will pardon the conjecture: at least 1 prior conviction for misdemeanor possession of controlled substances, misdemeanor interference with law enforcement, felony attempted trafficking of contraband into a correctional facility, 3 property-related felonies, and at least 10 related traffic convictions.
Very well. Court will set bond in this case at $10,000 cash or professional surety required. As a condition of that bond, the defendant must appear on time for all scheduled court dates and have no contact with Dakota Hinman, Tori Rakes, or Sierra Thomas. So you're obviously not to ingest any alcohol or illegal drugs as a condition of your bond, Mr. Vo.
Yes, I understand, Your Honor.
All right, so we've established bond in the amount of $10,000. Chris Pate has been appointed. Next court date in this court, June 2nd, 2:30 p.m. Anything else we need to address here, Mr. Regier?
No, Your Honor.
Then this matter is currently in recess. We'll move on to other matters. And I think that concludes my jail cases.
Yes, sir.
Thank you for your help there at the jail. Mr. Patterson, you appear as counsel on this docket. Do you have a client?
Ethan Buxton, Your Honor.
I'll address that next. It's the State of Kansas versus Ethan Robert Buxton, case number 2024 CR 443. If Ethan Buxton can come on fully at this time. All right, you can now see him, Mr. Buxton. Darren Patterson appears as defense counsel, Mr. Buxton on his own Zoom, and Jared is here on behalf of the state. Okay, you might go ahead and just mute yourself for a moment there, Mr. Buxton.
You said mute myself?
Mute yourself. I see a bond in the file that was established by second chance bail bonds in the amount of $2,000. Secured the defendant's appearance here today. I'll maintain him under it pending further proceedings in his case as may be necessary. Moving on then to the charges that have been filed in this case. Count 1 alleges criminal damage to property, a Class B misdemeanor. Count 2, possession of marijuana, a Class B misdemeanor. Count 3, possession of paraphernalia for use, a Class B misdemeanor. What plea is being entered today, Mr. Patterson?
Your Honor, at this time, we'd enter a plea of not guilty. Would ask the court to accept the bond in the case, would ask the court to set it for a misdemeanor control docket at the court's convenience. Thank you.
Okay. Court has approved the bond in this case. Again, $2,000 second chance bail bonds. I will require the defendant as a condition of that bond to appear for all scheduled court dates when this case is pending. It will be set before Judge Webster on July the 21st. This is a retained case, Mr. Patterson?
Yes, Your Honor.
What time are you proposing that this matter be set?
On July 21st at 9 a.m., Your Honor.
Very well. The court will set the appearance for Mr. Buxton at 9 o'clock a.m. on July 21st, 2025 before Judge Phyllis Webster. Mr. Patterson's already formally entered his appearance in writing and orally here today. So the court need not address court-appointed counsel. Court's approved bond, set a court date, and we have counsel secured. Anything else we need to address from the state's perspective? Mr. Regier.
Yes, Your Honor. It would appear that at the first appearance here in this case back in September of 2024, this court specifically entered a number of special conditions prior to the failure to appear insofar as setting bond was concerned. If the court is containing all of those, the state has nothing further.
Right. Are you familiar with these, Mr. Patterson?
Judge, I am not.
The original bond in this case, which he apparently defaulted on at one point, was no drugs or alcohol, or special conditions, may not return to the residence of Janice Steckdale. Mr. Buxton, if you'd unmute yourself for a minute.
All right.
Any problem with either one of those?
I mean, Janice Stockdale's my grandma. I don't know if...
Well, I may suppose there was a good reason for this.
Yeah.
Is there? Apparently it was a criminal damage to property allegation of something that belonged to Ms. Stockdale.
That is the state's understanding of the case, Your Honor.
Does the state still wish to maintain that restriction?
The state does so wish, Your Honor.
Patterson, do you want to be heard on that?
Judge, I hate to request this, but to be heard, I would need to have a breakout room with Mr. Buxton.
Well, counsel, without input directly from the alleged victim in this case, the court's not likely to relax the restriction.
Yes, Your Honor.
I understand the position you're in, but I'm going to go ahead and endorse those restrictions on this bond. No contact with Janice Stockdale. No alcohol or drugs. You can apply for relief on the bond by a request to Judge Webster at any time. All right. Mr. Patterson, anything further at this time?
Nothing further, Judge.
Mr. Regier?
Not from the state, Your Honor.
I will excuse Mr. Patterson and his client, Mr. Buxton, from the meeting at this time.
Thank you, Judge. Thank you.
Take up Justin Lee Thorburn at this time. Justin Thorburn?
Yep.
Is that yes?
Yeah.
Is that yes?
Yeah. Can you hear me?
Yeah, you almost are seeming a little disrespectful here. Can you just say yes or no, Mr. Thorburn?
Yes.
Okay, that's better. Thorburn, you want to, okay, we lost video for just a second. This is the State of Kansas versus Justin Lee Thorburn. It's case number 2023 CR 448. Jared Regier appears for the state, Justin Thorburn on his own Zoom. I do note that he did post bond through AAA Butler County bail bonds on May 6th in the amount of $10,000. It has security as appearance here today. I'll maintain him under it. Pending further proceedings in his case. I see a bench warrant bond forfeiture order out of Judge Crumb's court. Thorburn, you were supposed to have appeared before Judge Crumb on April 18, but you didn't. Why didn't you?
So I was supposed to go to treatment and I ended up not being able to make it. And I had forgotten that I had that court date right after, and because it had spaced out of my mind because I was supposed to be in treatment right now.
Okay.
And I ended up missing it. So,
All right. Was this on a probation violation hearing that you didn't show up for?
yes.
All right. I will reset it then. On Judge Crumb's docket for June 20, 2025 at 2:30 p.m. Mr. Thorburn must appear at the Butler County Judicial Center in El Dorado, Kansas, and no other location for that hearing. June 20th, 2:30 p.m. with you appearing, Butler County Judicial Center in El Dorado, Kansas. I trust you have an attorney that's been representing you. Mr. Watts,
Yeah, I
think
think
was
it's
there
Walt.
last time. The docket notes indicate from April that James Watts was your attorney. He remained your attorney pursuant to appointment by the court. You're on with Teresa Stanfill. Are you reporting
Yes,
to
Your
her
Honor.
currently?
I didn't know how to go about that.
Well,
I just bonded out 2 days ago. Do I need to report to her as soon as I get off here?
can you go to the office?
Yes.
Okay, then I'll direct you. to do so.
I can. Okay.
Okay. I think that's probably a good idea. So you're here in town then?
Yes, sir.
Okay. I'll direct you to go ahead and report to the Community Corrections Office today, and then follow that office's direction regarding reporting between now and your time of your hearing with Judge Crumb. Okay?
Okay.
All right. So Mr. Watts is still your attorney. We've got a court date set before Judge Crumb, June 20th at 2:30 p.m. And I've approved your bond. So just make sure you get over to the Community Corrections Office this afternoon, Mr. Thorburn.
Okay.
All right. Anything further, Mr. Regier?
Not in this case, Your Honor, although there does appear to be another case where a summons was recently filed and there was service on the same, involving the same defendant. I'm not sure if my notes indicate that it's set for a hearing later this month. I'm not sure if the court wishes to take it up now in the interest of judicial expediency.
I do not wish to take it up right now. That case is not before me. Mr. Thorburn, are you aware that you have another court date coming up?
If you could possibly tell me the date and the time, that'd be great.
Mr. Regier?
Your Honor, the state's information is in the Butler County District Court 25 CR 159. A summons was filed with the court with an appearance date of May 30th, 2025 at 1:30 p.m.
May 30 at 1:30, Mr. Thorburn. Can you get that written down
Okay.
too?
Yep. Thank you.
You've got another appearance requirement in court to face another charge.
Okay.
We'll order you as a condition of this bond to appear for all your scheduled court dates, including that one. May 30th at 1:30 p.m., Mr. Thorburn. And I don't know what that case is, but you can address it with the first appearance judge at that time. Okay?
All right. Thank you, Your Honor.
Thank you for bringing that to our attention, Mr. Regier.
Very good, Your Honor.
There's nothing further than the Thorburn matters. We'll be in recess at this time. You can leave the meeting, Mr. Thorburn. Get over to community corrections.
All right, I will. Thank you.
All right, someone's at court security 1, and I would trust that it's probably Tanya Ann Medina.
Yes, sir.
Okay. It's the state of Kansas versus Tanya Ann Medina, case number 2024 CR 335. Jared Regier appearing for the state. Ms. Medina appearing from the court security Zoom location at the Judicial Center. Apparently a bench warrant issued, Ms. Medina. You apparently had a scheduled court date before Judge Satterfield on July 12 of 2024 and didn't appear.
Yes, sir.
Why didn't you appear in Judge Satterfield's court?
Actually, because I didn't have a way over here. That's not an excuse, I know. And then I called over there. I called and they said they had a no hard copy warrant. So I didn't, and no, the first time they said that they didn't file a case on me yet. And then the second time they said that they didn't have no hard copy warrant for me. So I don't know what that means.
Well, what it means is you need to appear in court for all scheduled court dates, Ms.
Yes,
Medina.
sir. Yes,
So
sir.
I think you know what happens.
I usually do though.
All right, I do see that you posted out of Wichita, apparently,
Yes, sir.
a $10,000 bond in this case, as established by your assigned judge. Let me look and see who issued this. Judge Hart.
And Your Honor,
I will maintain Ms. Medina under that bond. It is, I'm not sure who the surety is on this bond.
It's
Do you use a
through,
bonding company, Ms.
yes,
Medina?
sir, Wichita bonding.
Wichita Bonding,
Mhm.
that's their name?
Yeah.
I have a
And then-
name of a Savannah Montoya, but I don't know who that bonding authority is with.
It used to be second chance bonding.
I see.
and Your Honor, for the court's edification, there does appear to be a second page to the bond, make reference to that particular bonding company.
All right, we need to set a date for you, Ms. Medina, in Judge Hart's court.
Okay.
The charges that are currently before us include non-residential burglary in count 1, a level 7 felony, count 2 theft, a class A misdemeanor in count 2, non-residential burglary, a level 7 felony in count 3, theft, class A misdemeanor in count 4, non-residential burglary in count 5, a level 7 felony, count 6 theft, a class A non-person misdemeanor in count 6, count 7 non-residential burglary, a level 7 non-person felony in count 7, count 8 theft and class A non-person misdemeanor, count 9 non-residential burglary, a level 7 felony, count 10 theft, a level 9 non-person felony, count 11 criminal damage to property, a class B misdemeanor. So be set before Judge Hart on his preliminary hearing docket, which is June 30, 2025, 2:30 p.m. Ms. Medina, you must
Yes,
appear at the Butler County Judicial Center in El Dorado, Kansas on that date for further appearance before Judge Hart.
Yes, sir.
Just like you did today.
Yes, sir.
Like you did today. But be there by 2:30 p.m. on June 30, so Judge Hart can further address your case.
Okay.
Can you afford to hire a lawyer?
No, I can't.
Are you working currently?
No. Just like kind of part-time-ish. Whenever they need me to clean their house.
All right, I'll find partial indigency at this time and will appoint James Watts to represent the defendant.
Okay.
So James Watts appointed. $10,000 surety bond approved. Court date before Judge Hart on June 30, 2:30 p.m. with the
Yes, sir.
defendant ordered to appear at the Judicial Center in El Dorado, Kansas.
Yes, sir.
Cool. Ms. Medina, do you have any questions?
No, sir, I don't.
Mr. Regier, anything further we need to address?
Not to my knowledge, Judge.
And the Tanya Medina matters in recess at this time. You're free to go at this time.
Thank you, sir.
All right, Mr. Regier, we've jumped around a little bit, regrettably, but I think that we've reached the end of this docket, at least as far as my list is concerned. Do you agree with that?
Forgive me, Your Honor, I'm experiencing a slight lag.
All right.
Your Honor, the state is aware of one other case, 25 CR 142.
Not on my sheet. What is that?
Defendant's last name Arnold, Your Honor.
First name?
Troy.
And what was the nature of the appearance that he was scheduled for?
Your Honor, the state's understanding is that a summons was previously issued in this case for an appearance on May 9th, 2025 at 1:30 p.m. Based off of the return of service in my file, there would appear to have been successful service via residential tack down on April 10th of 2025.
Mr. Regier, obviously, we don't have an appearance from that individual, and it wasn't on my list today to be addressed. What were the charges that were going to bring him before the court?
Your Honor, pursuant to the information followed by my colleague, Ms. Norris, on April 4th of 2025, this is a case that appears to allege one count of criminal damage to property, a Class B non-person misdemeanor. And for the court's edification, the charging language in count one does appear to refer to a particular detention facility. I'm not sure if that has any bearing on the court's consideration of this matter or not.
All right, Mr. Regier, I'm hesitant to issue a bench warrant for failure to appear based on tacking service, which I consider somewhat unreliable to provide actual notice to an individual for court. However, at this point, if you believe and your office believes that further summons attempts might be futile, then I would just ask you to go ahead and prepare a probable cause arrest warrant, and I'll go ahead and address bond. I would think a $1,000 cash or professional surety bond would be appropriate.
Your Honor, the
you may submit that to this court if you so desire.
Very good, Your Honor.
Okay. Mr. Regier, is there anything else that you believe we need to address?
Not in this matter, Judge.
Very well. And if there's anything further, that should conclude the Butler County first appearance criminal docket at this time. And the meeting may be ended for all. Ladies and gentlemen, that's all there is to it. Hope everybody enjoyed the court selections for the day. Did a little bit of everything from all around the country, a little bit of Texas, a little bit of Kansas, a little bit of Washington State. One sovereign citizen and a whole lot of regret. What can you say? I'm your Lone Wolf Oozle. I'm your curator for these here videos. I'm the host for this here weekend review. Ladies and gentlemen, I've got a lot more work to do if I'm going to bring more videos out. Come join us during the week. Judge Fleischer is no longer streaming, but that doesn't mean our 8 o'clock show is over. Come by every night at 8 p.m. Central Time. I think that's 9 p.m. Eastern Time. Check out some court dockets. We're calling it the Daily Docket Review. So come on by. We'll have a live chat going. I'll have a premiere running. We can all talk about what's happening on the screen. Ladies and gentlemen,
It's been fabulous chatting with you today. Thank you very much, everybody, for showing up and showing out. I'll see you next time. I am your Lone Wolf Usul, and I am out. Later. Oh, yeah. Love you, Mom. Ladies and gentlemen, tell my mom you love her, too. That's just... Everybody tell Mom. Happy Mother's Day! It's Mother's Day. We'll see you later. I'm out.